Good afternoon. Thank you all for finding time and joining our webinar. I also would like to give special thanks to our speakers for being with us. I do not want to take your time and would like to start asking my question to Joanna. My first question will be about bill of lading and letter of indemnities. What would be your suggestion for the owners if the bill of lading is delayed in the banking chain due to the impact of pandemic? Should they deliver the cargo against letter of indemnity, especially when the cargo is perishable, or should they wait until they receive the original bill of lading? What would be your suggestion here?
First of all, I would like to thank you very much for your kind invitation and the opportunity to address these extremely current issues. Turning to your question, inquiries of this type as a result of the late arrival of original bills of lading due to delays and the disruption of international transport at large have been raised by members. The position of IG clubs vis-a-vis the practice of agreeing to accept an LOI from charterers for cargo delivery without the production of original bills of lading is clear, and the recommended LOI wording that IG clubs circulated years ago was produced purely to assist members without, of course, endorsing the practice. The simple reason being that such a practice has an increased inherent risk of misdelivery. As a result, any claim arising as a consequence of such practice would fall outside the standard scope of P&I cover. Obviously, since an LOI is as good as the credibility of the charterer signing it, if a member found itself in a situation of enforceability, its only option may be to bring a claim before the director's discretion. The International Group of P&I Clubs has maintained this position during the COVID-19 pandemic, whilst in practice, other available options could be considered aside from the LOI scenario and its implications on club cover. An example, always depending on each cases and trade's particularities, the use of electronic bills of lading could be adopted utilizing IG-approved systems, although we do appreciate that e-bills are still uncommon practice. In this context, the use of C-way bills, subject to Hague or Hague-Visby rules, is another option, since presentation of the original C-way bill is not necessary and the master's duty is to simply cross-check the identity of the party taking delivery with the named consignee or shipper's nominated recipient, respectively. Furthermore, in the rare cases where an owner hasn't agreed to accept an LOI under the governing charter party, they could explore the prospect of discharging into a bonded area with the agreement to be released, the cargo to be released as soon as the original bills of lading arrive and are presented. As we all know, there is a significant number of owners who, as a modus operandi, agree under the charter party to accept LOIs in exchange for delivering cargo without the presentation of original bills of lading. So there is a very fine line that needs to be drawn between such modus operandi and genuine cases of inordinate delay.
Thank you so much. My other question will be about charter parties. Which clauses would be recommended to be added to the charter party in order to protect members' rights during pandemic?
In terms of recommended charter party clauses, a very hot topic has been force majeure clauses. So Unlike continental legal systems, where an overriding legal principle of force majeure is established in their respective civil code, under English or US law, there is no ex lege understanding of force majeure. This means that the notion of force majeure exists only in the context of an express contractual term. And in this respect, a force majeure clause in a charter party is a charter party clause that provides for the consequences of enumerated events beyond the control of the contracting parties upon the respective parties' performance of their contractual obligations. It is therefore important to bear in mind that on the basis of English law governing the charter party, force majeure per se acquires substance and meaning strictly through the specific wording of the governing charter party. As you appreciate, this inevitably means that each party's negotiating power will be the determining factor in the drafting and formulation or not of a force majeure clause. And as much as we lawyers like to lay down the optimum versions of such clause, depending on whether it is analyzed from a ship owner's or charter's point of view, in practice, it all boils down to the balance that can be struck between the two competing interests. More recently, we have seen BIMCO standard clauses for infectious and contagious diseases, which we do recommend to our ship owning members, being vigorously negotiated, considering the stakes in a pandemic situation. The definition of affected area is usually the most amended in the clause, whilst additional layers of reasonableness are often inserted. Importantly, subparagraph K, providing for indemnity of the owner for post-charter party term delays, expenses, and so forth, as a result of the vessel having called at an affected area during the course of the charter party, is often deleted. On the other hand, a clause may be inserted shifting any delays, expenses, and so forth as a result of the vessel's past employment to the owner. So obviously, the difficult market conditions are reflected in the apparent imbalance between the two contracting parties.
Thank you, Joanna. It was very enlightening for everybody who is entering into charter parties. My other question will be concerned with your personal experiences. As a claim director, what was the most frequently asked question during COVID-19 period, and what was your recommendation?
So from an FD&D perspective,
yeah,
the most frequent queries, especially at the earlier stages of the COVID epidemic, say in late January and beginning of February, revolved around whether or not an owner was entitled to refuse calling a Chinese port, as well as cases whereby charters would advise that they regrettably had to cancel the charter party due to the unforeseen COVID repercussions, which, for example, resulted in the cancellation of the corresponding shipment. Considering that English was the governing law, in the former cases, when an infectious disease clause had not been incorporated into the governing charter party, the member would need to rely on unsafe port principles. As matters stood at the time, it was difficult for COVID to render a port unsafe if it was not closed, since the risk of infection could still appear manageable. In such instances, an owner could seek to rely on its right to bring a implied indemnity claim against the charters for any damages or loss suffered as a result of complying with the charter's orders. So long, though, as the owner had not agreed to bear the particular risk. And this is where the virus spread status vis-a-vis the charter party date would be of essence. Now, in terms of charter party cancellations, as a result of the prevailing circumstances, we all know how difficult it is to satisfy the conditions of establishing frustration when there is no express force majeure clause. Therefore, the owner would be entitled to accept charter's repudiatory breach and treat the charter party as having come to an end, whilst reserving the right to claim hire and bunkers already incurred, together with damages due to cancellation. Obviously, the sensible resolution in such cases, after seeking charter's unequivocal confirmation that they will not be performing the charter party, was to explore a commercial agreement, as it is generally more likely for a charter to pay an agreed amount promptly rather than after going through the motions of arbitration or litigation, especially considering COVID-19 related delays and the uncertain status the charter will have by the time a final award or judgment is issued eventually. So without a doubt, the outcome of each case lies with its specific facts and, very importantly, with the status and credit worthiness of the member's respective counterparty. And invariably, we FD&D insurers find that this is to a significant degree the driving force behind the resolution of a dispute.
Thank you. The last question is actually one of the most frequently asked questions for us during this period, and it's about crew contracts. Could you please advise what are the club's recommendations when it is necessary to extend the crew contracts as a result of COVID-19 restrictions?
The COVID-19 pandemic created unprecedented circumstances and challenges for ship owners as a result of quarantine measures, travel restrictions, and border closures, since seafarers were and still are prevented from traveling to and from vessels. International organizations have made both individual and collective efforts for seafarers' special status to be recognized, which would allow necessary crew changes and repatriations worldwide to be effected without inordinate delays. Organizations such as the ILO have issued very useful notes and guidelines for ship owner employers who have, from our experience, managed to adjust their operations to the challenging circumstances with the assistance of their respective flag administrations and governments, which had to adopt a pragmatic approach due to imperative reasons of public health vis-a-vis the extension of employment contracts, the adjustment of minimum safe manning, and the extension of medical certification as well. So from the American Club side, as Jonathan mentioned, from a crew cover point of view, nothing changes when a contract is extended. We, in full appreciation of how Port State COVID-19 prevention and mitigation policies continue to challenge our members' crew change plans in many parts of the world, we have further extended the validity of the American Club pre-employment medical examination certificates up to May 31st. In my personal opinion, the biggest enemy in situations of contract extensions is psychological fatigue, which is why we insist on reminding our members of our mental health guidance and our website, where we maintain a list of mental health contacts. Thank you.
My questions are over here. Thank you so much for sharing your comments, recommendations.